All rise. Court's back in session.
I want three of you and actually rise for you to come here.
Sorry. No, it's all right. We'll give him a few moments. Be seated, please. All right. I want to say first and foremost to put a case on someone else unless there is a true conflict, which there is not. The defendant, through counsel, Ms. Thompson, filed a motion pursuant to Rule 10B of the Tennessee Supreme Court 101 for the court to be recused in this case. And in her memorandum set forth grounds. I want to dispel some of those. First of all, I think it's very clear at this point that the telephonic conversation on that Friday prior to the conference call was of short duration with absolutely no discussion concerning the merits of this case. As I've done on other occasions, I encouraged counsel to see if they could work the matter out. Said if you can't, you call my office, we'll do a conference call. It was my intention that that would be done quickly because we've got a trial date approaching, and I wanted to resolve the issue as soon as possible. At this particular time, I'm not going to get into the disqualification of Mr. Evans. I will take that up in a few moments on the defendant's motion. But there was no ex parte conversation. That didn't occur. Any conversation was towards scheduling, which is expressly allowed under the Tennessee Supreme Court rules, judicial conduct. As far as the matter on negotiations, as has been pointed out from day one, I've negotiated the parties, or I've tried to encourage negotiation between the parties. That was confirmed by the attorneys that at one time I actually said it's not too early for the parties to start negotiations. I think any good trial judge is not being responsible if they don't ask the parties in good faith to negotiate. The system without negotiated plea agreements would absolutely break down. So that's part of the process. And yes, you're right, I have encouraged it. I've encouraged it a multitude of times. I've attempted to encourage it firmly, but not coercively. I want to make another thing clear concerning me speaking of negotiations. I did get a call from one of the attorneys. They advised that they would not be needing a trial date. There were no discussions of the merits whatsoever. Is that correct, Mr. Show?
That was from me, Your Honor.
Yes.
I gave you 2 phone calls, one of which was to ask about what the procedure would do in a plea agreement in Your Honor's court for approval. And then I told you I would notify Your Honor if we had felt that we were not going to be at
I
trial.
have never discussed whatsoever your client's case, have I?
We have not, Judge. I also told you on my second phone call.
That I would not be needing, that you would not be needing a trial date.
Second phone call, I told Your Honor we would not be at trial.
So that was probably what triggered what I said, that given recent developments in the case, that I would further ask the parties to negotiate.
Judge, and I did that with the state's knowledge.
And then as I said, I don't see the negotiations that the court asked the parties to engage in negotiations as showing any bias whatsoever of the court, and I don't have any other attorneys in here in other cases, but I've got police agents that will tell you it's not unusual in this particular case, that it's frequently done, that I've asked the parties to engage in negotiations. It's no comment on the presumption of innocence that the defendant has. It's simply that the parties need to have some reasonable dialogue concerning their case. And concerning the fact that the court has said that I don't intend to continue the case, I guess that should be modified somewhat to indicate that I don't intend to continue the case absent good cause shown. And for good cause shown, it might be the unavailability of a material witness, it might be sickness or something on behalf of an attorney, but what I've tried to encourage the parties to fully understand that I don't want to get to the trial date and then have someone say, Judge, we're not prepared to go forward. Because it's been over 2 years. I think I could ready myself to try the Nuremberg trials in 2 years. So that's what I meant. Good cause shown, the court might have to, but it's firmly my intention to go forward as scheduled. So your motion for recusal is hereby overruled by the court. You want to proceed on your second motion?
Yes,
All right. It's a motion to set aside order disqualifying Luke Evans as attorney of record for Zach Adams. And I want to make a preliminary statement concerning that at this time. I have never, to my knowledge, set eyes on Luke Evans. I'm assuming this might be him in the courtroom, but I don't know. And I think he will confirm that. I will say that anything that I know about Luke Evans' involvement in this case was gleaned from a public record. I was preparing to hear a motion for injunction to enforce an immunity agreement that was filed in the Chancery Court of Decatur County. Frequently, I interchanged with the Chancellor, and she was fairly new at the time, and I was prepared to hear it. And then the untimely death of Mr. Shane Austin rendered the case moot. But is that not correct? We've never met, to my knowledge, have we?
That's correct, Your Honor. I think we had a teleconference in that case.
We did in that one? I didn't even remember that.
Yeah, we had with Scott Sutherland, with the Attorney General's office, myself, and yourself. It was a scheduling conference regarding setting a hearing out prior to Mr. Austin.
And then upon his demise, it was moot.
That's correct.
Okay, thank you. All right, proceed with your motion, please.
Yes, Your Honor. I would like to call Luke Evans to testify.
Okay, come around, sir. I want you to raise your right hand, please. Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Would you state your name for the record, please?
Luke A. Evans.
Okay. And how are you employed?
I'm an attorney.
Okay. And who do you practice with?
I'm a law partner at the law firm of Bullet Fly, Hornsby & Evans in Murfreesboro, Tennessee.
Okay. And can you explain to the court how it is that you came to be involved in the representation of Zachary Adams.
Yes, I was contacted by you and asked if I would be both willing and able to engage on behalf of Mr. Adams. In response to that inquiry, my first statement was that I needed to check with the BPR because I have previously represented Shane Austin.
Okay, and did you in fact check with the Board of Professional Responsibility?
I did. I contacted them immediately after speaking with you on November 23rd, 2016. I spoke with Stephen Christopher that afternoon in detail about the issues related to any potential conflict that might exist and ultimately might.
We use the acronym BPR, Board of Professional
Yes.
Responsibility. We've got a lot of people that are non-lawyers.
Sorry. So I called the Tennessee Board of Professional Responsibility and ran it by Mr. Christopher in detail.
Just what details did you tell him? I mean, what facts did you make clear to him when he made the decision that, or when he advised you that there would not be a conflict?
On that date, I alerted Mr. Christopher that I had previously represented Mr. Austin, who had not been indicted in the case, but was considered at the time a person of interest in the investigation. I let Mr. Christopher know that I had filed a civil suit and litigated the issue of enforcement of an immunity agreement in the Chancery Court in Gator County, and that there was a proffer attended for those who don't know what a proffer is, where myself and Mr. Austin met with several agents from the TBI one evening and had a discussion with them, as well as I had some interactions with Ms. Beth Boswell, who was the attorney at the time handling the case.
Assistant District Attorney.
Yes, sir. Had some discussions with her in negotiating an immunity agreement. I then let Mr. Christopher know that after all that had transpired and we were litigating in Chancery Court, that Mr. Austin had unfortunately taken his own life and was now deceased, and that I had been contacted by the defense team for Zach Adams with an inquiry as to whether or not I could possibly be one of his attorneys.
And what did you advise the board as to Zach Adams and what your role would be and how his case related to Shane Austin?
Well, what I advised the board and what I had been, information I had received from the defense team was that essentially there would be a consistent defense theory at play in trial.
And what does that mean, consistent defense theory?
Essentially, from what I understood from speaking with you initially, that your argument on behalf of Zach, and therefore Zach's argument, was that not only was he innocent of this, they were all innocent of this.
Okay.
Including Shane Austin.
Okay. And so then, did you relate to them any additional information?
Not that I
Like
recall.
whether Zach had been charged?
Sustained.
Did you relate to them any information about the status this case was in?
I did let him know it was a death penalty case that was currently pending with Zach Adams. I'll know who the other co-defendants were in the case, I believe, when I was discussing.
Okay. And then, based on that, what did you do next?
Well, I received an informal opinion from the BPR, which was provided to the court. That day, I just received it verbally from Stephen Christopher, and the opinion was that there was a conflict of interest. My understanding of his opinion was that essentially Mr. Austin was.
Let me say the parties furnished, or they sent some emails, both sides, discussion of this issue and the opinion, which were forwarded to me by the staff attorney. I don't actually get emails directly from any of you. They either come to Sherry or they come to Susan Jones. But I was made aware of the email correspondence. So I didn't engage in any explanation parte, I viewed emails that had been exchanged between the parties.
Yes. And I'd like to pass up to you a paper. And do you recognize what that is?
I do. This was this is a copy of the email inquiry that I ended up asking Ms. Laura Chastain to send me when I contacted them on January 18th. But it was generated, my understanding, by Mr. Christopher on November 23rd in response to my call.
Okay, so will you tell me then what happened? He gave you an opinion,
Yes.
and after he gave you an opinion, what did you do next?
I immediately contacted you back and let you know that I was cleared from the board's perspective. There was no conflict of interest, no issue related to my being able to engage in the representation of Mr. Adams. And so from that perspective, that I was able to proceed and also willing to proceed should the court see fit.
Now, do you understand that there's a difference between having represented someone in a criminal action versus having represented them in a civil action?
Yes, and that's one of the things that the Mr. Christopher made clear when I spoke with him, was that essentially it would almost be.
I would object to what Mr. Christopher may have said in the telephone call between this witness, and we weren't present for it.
He says hearsay, all right?
Right, but based...
We've got the written email, which the court will consider, but what the prior conversation, he can say, which he already has.
Right.
We had it, I disclosed things, he said there was no conflict. We've already filed that.
Okay. But what do you understand after doing research and looking at the information is the difference between having represented someone in a criminal matter versus a civil matter?
Well, essentially my understanding upon review of the rules and what I considered before engaging in this case was, could I ever be in a position to take it in representing Mr. Adams that would be materially adverse to Shane Austin, my former client. Upon my review of the rules and current understanding of everything I've reviewed, the state is essentially in a spot where they cannot take any further adverse action against Shane Austin in a criminal matter because he is deceased. You can't, unfortunately, he's deceased, and you can't charge somebody who's deceased with a crime. So, my understanding of it from that perspective was that wouldn't be in play. There was no current concern about a conflict that's related to Mr. Austin. I also understood it based on the opinion that was rendered that I could not disclose any confidential information I gleaned through my representation of Shane Austin. And based on everything I reviewed and understood, my current representation of Zach Adams would not require me to do that.
Okay. And was it your understanding, what if at some point the defense team decided to go with a different theory that perhaps implicated Shane Austin? Would that have affected your ability to represent Zach Adams in this case?
I don't believe so, based on everything I looked at again, because the test is not, the test is based upon the review of the rule, whether or not it would adversely affect the former client. And again, even if you, theoretically, even if Mr. Adams took that position, it still would not have been the rules of professional conduct because it wouldn't have an adverse effect on Mr. Austin.
Okay. And did you also talk with Zach Adams in this case?
I did, absolutely.
And did you discuss with him your representation and the fact you had represented Shane Austin?
Absolutely, and I discussed that with Mr. Adams, and I discussed that with you as well. And the sole purpose of that was almost, from my perspective, was a belts and suspenders type of I deal to ensure that there was a conflict waiver signed by Mr. Adams. I wanted to, on top of, even though I don't think it was required, based on my understanding of the rules of ethics, I wanted to make sure that I had it. I wanted to make sure that he understood it and that there was no issue with that. So yes, that discussion.
And what I have put before you, do you recognize that?
I do.
What is that?
That is the conflict waiver that you provided me that was signed by Mr. Adams.
Okay. I'd like to make those two things exhibits.
They're attached to your pleadings. That is Exhibit B to your pleadings.
I guess my fear is, Your Honor, I'm aware of another case that went up on appeal, and the court said because it wasn't made an exhibit to the testimony, that something that's in the pleading doesn't meet the standard. But that's
Send the pleadings up. There's no-
Yeah, what?
We'll just send the pleadings up.
The pleadings will be sent.
I'm just trying to cover all the bases. Okay, so after you had received the opinion from the Board of Professional Responsibility, what did you do next?
Your opinion is Exhibit A. It's attached, okay?
Yes, Your Honor.
After I received the opinion from the Board of Professional Responsibility and informed you of that fact, I waited to hear back because it was my understanding that you and Mr. Simmons were going to approach the court regarding employment in this case.
Okay. And at some point, then, when did you begin work on the case?
December 29th, if I recall correctly, approximately December 29th, September 30th.
And when did you file your notice of appearance in this matter?
I'd have to see the date on the notice of appearance, but I would say maybe January 7th rings a bell, but I couldn't be sure. Whatever date stamp filed on it, or whenever the email was sent.
Okay. And what happened after that?
Well, immediately upon being notified by you, Mr. Simmons, that I've been appointed subject to AOC approval by the judge, I began working because I knew that there was a trial date looming in April. Sent the notice of appearance out. We attended a discovery conference with Mr. Christensen and Mr. Hagerman and several members of the TBI, I think on the 11th and 12th of January. Worked through that. Sometime after that, I received a email from Ms. Nichols, Ms. Jennifer Nichols, saying that she had a concern about potential conflict.
And when you received the email from her, what did you do next?
I responded to Ms. Nichols' email, probably within a few minutes or a few hours, something to that effect, but on the same day, to let her know that I had taken steps to ensure that there was no conflict of interest, that there was no issue, and that my representation to Mr. Adams didn't in any way offend the rule of professional conduct.
Then, as far as you know, what happened next is regarding you representing Mr. Adams?
I believe I received another email from Ms. Nichols at that point in time that said that, again, I think she stressed her overall concern, saying that she believed there was a conflict. That's not her exact words. And at that point in time, I contacted the BPR again. I believe that was January 18th. I contacted the Board of Professional Responsibility. On that day, I spoke initially with Ms. Laura Chastain, who forwarded me the inquiry on December 3rd, and then spoke again with Mr. Stephen Christopher. During that conversation, I let Mr. Christopher know that the concerns that had been raised by the state, I think I even read into our conversation, emailed.
And I'm going to object.
Like you're saying.
Oh, it's what you did, right? You're talking.
Right.
He's also saying what the party responded. and what
He can say what he did, but
Yeah, well, just tell us what you did.
I don't see that it's any good. We can't know what the response is.
What did you do?
I read in the email that Ms. Ellis had sent me.
So you made her concerns known to the Board of Professional
I
Responsibility?
did.
What happened after that?
The email that was forwarded to me by the BPR showing that no conflict existed.
Okay. And what was your next interaction with the prosecutors in this case?
The next interaction I had is when we left this discovery conference, we had been discussing several issues of deficient discovery, or missing discovery, or that we couldn't put our hand, at least discovered that the defense is not going to get made aware of in some cases, or been provided. A list was then done by your paralegal who was present in the meeting and sent to the state, and I was, again, concerned about the upcoming trial. They emailed out to Paul Hagerman to say two things. One was, hey, we just want to check status on the discovery. Where are we on that? The second part of it was to inquire about any proper statements that they had received from Jason
Yeah,
Long.
for that, on that objection at this point, I don't see we're getting off. The purpose of this hearing is whether or not there's a conflict.
Right.
And we are well beyond that. I sat silent for a minute to see where we were going, but I think any conversations that we now have crossed over.
Concerning discovery, anything else is irrelevant.
Well, but but I'm just trying to outline the facts as I have them in my motion as to what led up to us having the telephone conference and him being disqualified. So what I was wanting him to, get to is just what Paul Hagerman had said to him, and then what he did from there, how we came to have the telephone conference.
And, Your Honor, the discovery issues has nothing to do with how we came to have the telephone conference. And actually, those emails are also attached to the state's filing this morning so that Your Honor would have benefit of those. But I still say it's hearsay and it's not relevant to whether.
I don't see relevance.
Okay, so then let's just go to the telephone conference. You were a party to the telephone conference?
I was.
And in that conference, was there any new issues raised or new facts raised in the conference that would justify you being conflicted out?
I'm going to object, Your Honor, since it's not his opinion about whether he's, it was your purpose of the phone call was to voice
Let me
the
say, I didn't let either side argue anything that day. I said that upon further reflection, I reached a conclusion that he could no longer ethically be part of the representation. That just based upon facts that I knew essentially from his prior representation concerning the fact that for all intents and purposes, he was representing a fourth co-defendant.
Okay, so
But I think both parties will agree, I didn't ask the state for anything further, nor you further.
yes, that's the point that I was trying to put in. And so then no further questions, Your Honor.
All right. Cross-examination.
Mr. Evans, I was trying to write down the items that you said that you provided to BPR on the call, and I wrote down, you advised them that you had previously represented Shane Austin, correct? You said yes.
Yes.
That you had advised them that you had engaged in proper and immunity discussions,
Yes.
and that would have been with both the assistant district attorney handling the case as well as special agents with Tennessee Bureau of Investigation. Now, that any discussions with Beth Boswell, present at the actual process?
She was not present.
Present at the actual process, a number of special agents. Correct?
Yes. Yes.
Did you advise them that you had filed a chancery action?
Correct.
And that was upon Beth Boswell, Hanson McAdams' determination that your client at the time, Shane Austin, had not been completely forthright and honest.
Can you repeat that? I'm sorry.
You filed a chancery action to enforce the immunity agreement when Hanson McAdams and Beth Boswell withdrew your offer of immunity.
Correct.
And they withdrew that because, in their estimation, as is evidenced by correspondence from them to you, that they did not believe that he was completely honest and upfront.
That's correct.
Okay. And you told the board that you had discussed this case with Beth Boswell,
That's correct.
And you told the board apparently that it was a death penalty case.
That's correct.
You did not, however, because Ms. Thompson asked you, was there anything else? You told them anything else? You said no. So you didn't tell them that Shane Austin said that Zach Adams told him that Zach Adams, killed Holly Bobo. That wasn't in the list of things, correct?
Back up again. You're going to have to repeat the question.
All right. I will back up. 2 questions. Ms. Thompson specifically asked you whether the list of items that I just read were the sum total of what you discussed, what you provided to BPR. You said it was.
I don't recall giving that answer as a conclusive answer.
Well, yes or no, you said yes, so you're saying now that's not conclusive?
I'm saying that
Your Honor, I didn't ask that question. I didn't say, is that all you told them?
Well, she did.
Is that all you told them?
no.
Okay,
So,
so,
yeah, I mean, it depends on which day. 'Cause I talked with them in the original letter on the 23rd, then I spoke with them again on January 8th. So they're
in any conversation with BPR, did you advise them that your client, Shane Austin, told 3 special agents with the Tennessee Bureau of Investigation that Zach Adams killed Holly Bobo?
not those words, I think.
Okay, thank you. Did you
want me
tell?
down? If you
No,
want me to finish.
that's enough.
He's allowed to explain. Answer yes or no, and then if you wish to make explanation.
What I told them was that during my representation of Shane Austin, that he did in fact commit a fraud, where he made statements that implicated Zach Adams. Absolutely.
Okay, well, that's what a proffered immunity, that wasn't my question. So my question was, did you actually tell the Board of Professional Responsibility that your client, Shane Austin, said Zach Adams killed Holly Bobo?
I wouldn't have said that.
Okay.
I don't recall him saying that.
You wouldn't recall that?
I said I would not have said that because I don't recall my client Shane Austin saying that during the proffer, ma'am.
And you didn't, I assume, tell them that your client, Shane Austin, told you that Zach Adams said he put her in the river next to a rock that had an orange T painted on it.
I wouldn't have specifically said that, no. I didn't, no.
Your Honor, I object. Ms. Nichols is mischaracterizing what was said in the proffer.
I'm sorry.
Shane Austin did not say...
She's allowed to ask the questions if you want to
But
re-examine.
she's mischaracterizing what was said in the proffer for the court. That's not what was said in the proffer.
Go ahead.
Your Honor, I'm reading from a report, and have spoken to the agents and have spoken to Ms. Boswell. I assure Your Honor, now, as in every other time I've appeared before you, I don't misrepresent what I believe to be the truth based on the evidence in front of me.
All right.
This is important, and I want to know what the board had in front of them when they issued or confirmed the defenses were similar. Because it seems highly unlikely that Mr. Evans may actually advise him of
He
this.
didn't say similar, he said consistent.
Consistent.
All right.
So that's no, you said you didn't tell him that.
None of those exact words, because...
Okay, in any other
Ma'am, Your Honor, if I may have the opportunity to complete my answer.
Go ahead.
I wouldn't have told them specifics, number one, because I didn't have the benefit of that report or the specific recollection that you're able to recall reading a report that I didn't have the benefit of when I called the...
So if you didn't have the benefit of the report, you have the benefit. You are the person who, in the course of this proffer, assisted the special agents in getting a handwritten note from Shane Austin that implicated Zach Adams. Surely you have recollection of that.
I do.
And did you list for the board the 5 statements that Shane Austin wrote on his handwritten note?
No, because I didn't have it before me, but if you would have emailed it to me, I would have been glad to discuss it with the board at any given moment.
And you'd agree with me, Mr. Evans, that we, the state would have no way of knowing that you were trying to have yourself put on this case?
No, I mean, when you emailed me on the 18th or the 16th, if there's anything you wanted me to let them know, I would have been glad to do that.
So Shane Austin told you that Zach said, I will make you disappear like I did that girl. That's what he wrote, right? In your presence.
You didn't tell me.
That's what he wrote in your presence during the course of the proffer.
Can I take a look at that?
No. I mean, I'll pass up in a minute. I want to see what you remember.
I don't know.
Okay. Do you recall that he said, that he wrote, I had her chained up in the back and called Shane to, please excuse me, Your Honor, fuck her. Remember that one?
When I recall,
Wait a second. I don't want any disturbance out there.
no, I don't recall that being said.
Do you recall Shane Austin writing in your presence and you providing it to TBI, you have to gut them so they won't float?
What I recall in that interaction, ma'am,
And I'm going to ask you to answer yes or no and then explain
I
as
don't
the
recall that
judge.
specifically, because, no. But that's not what it said.
Do you recall Shane Austin writing in his own handwriting that Zach said, I put her by the teeth in the river. They'll never find her there.
I do recall that, yes, ma'am.
Do you recall Shane saying, Zach said, no body, no crime?
I do recall that.
So those items, the ones that you recall today, the ones that you don't, were not provided to the BPR when you spoke to them, correct?
Not specifically in those words. What was provided to the BPR was me running through factual scenarios like, if my former client absolutely said that the current client had admitted to doing it in certain times, in certain places, would that in any way affect my ability to engage in representation of the current client if my former client was now deceased? I think that pretty well covered all those statements, but it would have to be an accurate reading of those statements too.
And you would agree that the email that you received from BPR says the caller confirmed. You're the caller, right?
Yes, ma'am.
So Luke Evans confirmed for the Board of Professional Responsibility that the legal and factual positions of the former client and prospective client with regard to the criminal allegations are consistent.
Correct.
So despite the fact that you were present for this proffer, and despite the fact that you were present when your client at that time wrote those 5 things about the person you now want to represent, you confirmed for BPR that that was consistent?
Absolutely. Their positions, from what I've been informed from the defense team, are absolutely consistent.
And you were present here at the telecom, of course, when the judge disqualified you from continuing to represent Zach Adams, correct?
Yes.
You heard him make statements, of course, about the appearance of impropriety or conflict of interest with respect to the public and the family, and the public's confidence in the judicial system.
Yes.
Okay. And would it surprise you to know that this family and these friends of Holly Bobo would have a significant problem with you representing Shane Austin and then now representing Zach Adams? Would that surprise you? Because that's the public.
Well, it wouldn't surprise me. I can't begin to imagine what those ladies and gentlemen have endured. That wouldn't surprise me. But that's not the legal standard. Appearance of impropriety is not the legal standard here.
And I appreciate you trying to educate us, but that wasn't my question.
Okay, well,
You understand my question?
I answered it, ma'am. You need me to explain it?
No?
Okay.
You answered affirmatively. Would you agree with me, or you wouldn't be surprised?
But I said, look, I can't imagine, I can't begin to imagine it.
Have you ever had a death penalty case? Ever tried one? One. Sorry, what'd you say? Have you ever
I
tried
haven't
one?
said anything yet. I previously handled a death penalty case that,
Sorry, that wasn't my question. Have you ever tried a death penalty case?
no, ma'am.
Despite never having tried a death penalty case, you're aware of the scrutiny placed on those cases in the event of conviction down the road. Correct?
Sure.
You read about that, I assume. Since you haven't tried one.
And I've tried multiple homicides, and I'm aware of the heightened standard, and I've handled other death penalty cases.
But haven't tried one.
Luckily, they took that off the table before I went to trial, so
You saw this waiver
I did.
that Ms. Thompson attached to her pleading. You recognize that as being her handwriting, I
I
assume.
did.
And you read it.
I have.
And it's your position, you're going to sit here under oath as an attorney and tell the court that you should stay on this case despite the fact that you guys got the defendant, Zachary Adams, to sign a waiver saying that there might be conflicts in the future. We don't know about them yet, but that's okay.
I don't understand your question.
What? You told us that in part you based the fact that you didn't think there was a conflict on the waiver and on the BPR opinion. Is that a yes?
Yeah.
And so this waiver says, there may also be actual conflicts at some point in the future. I have discussed this matter with Jennifer Thompson and am willing to waive any conflicts.
Okay.
So in other words, what's his educational background? Zach Adams.
I don't know if that.
Right. And that might be an important thing to know when you obtain this kind of a waiver from somebody, right?
Well, I didn't take the waivers.
Now, I'm just asking because you said you handle so many cases.
Sure.
And so if a person doesn't understand what they are being asked to sign and what they are waiving away, that would be a concern, wouldn't it?
If that, no, absolutely. If it was in fact the case that the person didn't understand, sure. That would be a concern.
How many capital post-convictions have you done?
One.
Do you understand that this waiver, Mr. Adams agreeing that he's waiving things in the future that he doesn't even know about, would not stand over the course of time when looked at in the post-conviction arena, separate and apart from your BPR clearance to proceed? This is a different issue.
Are you giving me a legal opinion or are you asking me a question?
That's the question.
You're going to have to restate it because I didn't ever hear a question.
Do you understand, given your vast experience, that this kind of waiver would not stand the time when it's looked at later on if he's convicted?
I don't understand that because I don't know that you can understand that either. Because we're not the courts and we're not in the future.
So you don't know the answer to that question?
No, ma'am.
What another Trevor?
I need to ask you, I've left some documents back there. Is that proper that you've been referring to? I either need that in exhibit or I need it attached to pleadings.
I'll get you a clean copy. It's,
Okay.
It's attached to the plan.
I have something circled on mine. I'm going to get a clean copy for you. And you should have it, but I wouldn't want you to have to sift through the hard drive because it's IR.
Let's just file it as an exhibit.
Okay. And
One.
what number is it? One that what the question?
Judge,
In the board
it's an
opinion
attachment to her response.
that you shared
Still
with
want
us,
that stamp.
it actually says that that opinion is not binding on any court, correct?
Absolutely.
Or anyone else, for that matter.
That's correct.
It doesn't afford you protection either.
No, it does not.
Your Honor, I've got the hour, but I just want to get a clean copy that's not circled, but I'll go ahead and file it, maybe I'll substitute, we show the defense counsel's got a couple minutes circled.
I think we got a clear copy. We found it.
And it has an attachment.
Right here. Hand that to her. See if that's,
That's the attachment to the proffer.
okay.
The actual proffer that Ms. Thompson was indicating.
Well, the attachment was what you were reading from.
Actually, I was reading from both, Your Honor.
All right.
Let me pass forward.
I've got it. Let's,
I don't think that's what she has. That's not what.
No, sir. That immunity agreement we discussed, but I'm passing forward. That's what I was reading from the part.
it's got some markings. It makes no difference to the court. The handwritten was attached to the, to this. All right. Then that'll be Exhibit 1.
Nothing for you further.
Yes, I'd like to see Exhibit 1 if I could, please. Now, would you agree with me that saying somebody killed Holly Bobo and saying somebody said they killed Holly Bobo are two different things?
They are.
Okay.
Your Honor, I'm going to object to relevance to whether.
No, let her go. Let her go.
And so when Shane Austin went in to give his proffer, he specifically told the TBI that he never believed that Zach Adams had actually done those things.
If I recall.
He was telling the TBI what he had heard Zach Adams say before.
Yes, that's correct.
And the statement, if you look at this IR report, the statement that he made about having Holly chained up, Shane Austin said that Zach Adams said that in a bar. Isn't that right? And Double D's or Johnny's?
I'd have to look at the report and see what it says.
I'll just pass it to you and refresh your memory.
That's correct.
I just want to refresh your memory on the whole thing, and then I can ask you more questions about it.
Your Honor, can we have a sidebar conference, please? The attorney's judge.
Yes.
Would you like here?
Let's go back there. I'll have the court report join us.
All rise. Court will be recessed. The,